Well, thanks, Kai, for the introduction. Hi, everyone, and it's a pleasure to be here. I've shared the screen. I don't know if everyone
Yeah,
can
I
see
can
this.
see. We can see.
Oh, okay.
Very clear.
Yeah, perfect, brilliant. So, um, as Kai mentioned, I'm Behnam Khatami, managing partner of Nami Associates, a top-tier law firm in Iran, and today I will be discussing confidentiality and non-compete agreement under Iranian law. So basically, in my experience advising multinational companies, these clauses are frequently included in contracts relating to employment, joint ventures, distribution and agency agreements, and also technology transfer. However, when it comes to Iran, the key issue is not drafting. Uh, it is enforceability and strategy and how to structure things. So today I will focus on three things: the legal framework in Iran, the practical enforceability, risks, and more importantly, how to structure these clauses effectively in practice. So let me start with confidentiality agreements. Under Iranian law, first of all, there is no mandatory requirement to include confidentiality clauses in contracts, but they are widely used in practice, particularly in commercial and employment arrangements. More importantly, confidentiality obligations are generally enforceable as a matter of contract law principles. So that said, there are important nuances. Iran does not recognize confidentiality as an absolute right. For example, courts or authorities may override confidentiality obligations. In some cases, disclosure may not even give rise to damages. So, this is a critical distinction compared to many Western jurisdictions. And because a statutory protection is limited, the contract must do the heavy lifting. In practice, I recommend a clear definition of confidential information, express use restrictions, inclusion of liquidated damages or contractual penalties, and also post-termination survival clauses. So confidentiality clauses in Iran are valid, basically, and generally enforceable, but only as strong as they're drafted. Now, turning to the more complex issue, which is non-compete clauses. This is where many foreign companies face surprises. First, although there's no explicit prohibition, there's also no clear framework. Under Iranian law, there's no express statutory prohibition on non-compete clauses, but on the other hand, there's no clear legal framework supporting them. So this creates a gray area, which needs to be dealt with properly. The other issue is that enforceability is uncertain. Unlike confidentiality clauses, the enforceability of non-competes is not well established in Iran and basically in Iranian case law. Courts have not developed a consistent approach, and as a result, many practitioners consider them weak or difficult to enforce, and their use is not common practice in Iran. Um, in addition to this, there are also public policy considerations. There is a strong underlying constitutional principle in Iran, which is protection of the right to work. This means overly restrictive clauses may be viewed as contrary to public policy, and courts may refuse enforcement if they limit a person's ability to earn a living. So if used, they must be limited in scope and reasonable. In line with general global principles and emerging Iranian practice, enforceability depends on the scope, which means what activities are restricted, the geography, and duration. And courts are more likely to consider enforcement where clauses are narrow, justified by legitimate business interests, and linked to confidential information or trade secrets. So how we should treat these clauses and how to structure them is very important. There are mainly four strategies to adopt. The first one is to prioritize confidentiality over non-compete. A strong confidentiality clause is often more effective than a non-compete because it is easier to enforce. It directly protects sensitive information. The second strategy is to use hybrid approach and hybrid clauses. And instead of a pure non-compete clause, put in place an overarching structure by combining several clauses, including non-solicitation clause, non-dealing provisions, and also confidentiality, along with IP protection clauses. And then these are generally less restrictive in Iran and more defensible when it comes to enforcement. The third strategy is to use contractual penalties. Iranian law is generally respective to liquidated damages or penalty clauses, unlike some Western jurisdictions. And this can act as a deterrent and reduce reliance on certain court enforcement. The fourth strategy is a structural protection beyond contracts. And in practice, the most sophisticated clients rely less on legal clauses and more on operational structuring, limiting access to sensitive information, segregating know-how, and exerting a need-to-know approach, and using offshore structures where appropriate. There are certain contexts which these clauses are more commonly used, and then treatment of these clauses become board. These are joint ventures and employment, in our experience. In joint ventures, non-competes are more accepted between companies, still must be carefully limited. And in the context of employment and labor law, and basically labor contracts, non-competes are weakest, and confidentiality and internal policies are key and most honored by the relevant authorities. So let me conclude with three clear messages. Confidentiality works in Iran if well drafted, and it is your primary protection tool in Iran. And non-competes are uncertain. They exist, but not clearly regulated and are not consistently enforceable. Stakeholders must think beyond clauses, and they must put in place the most effective approach, which is a combination of legal, structural, and operational protection. And as final remark, I would like to say that Iran remains a highly sophisticated but unique legal environment for multinational companies. Success depends on understanding how law works in practice, not just in theory, and adapting contractual strategies accordingly. Thank you so much. And in the end, I would like to appreciate your attention, and I will be happy to respond to any question which may come along during the course of the webinar. Thank you.
Thank you.